where a referral can be made to a government office for the provision of supports to avoid a substitute decision-making order. So I don't know how people in the disability community, whether they think that this has been any help to them. But I do know that the wording in the legislation and that the intent of trying to find a mechanism to get the government to provide supports to avoid a substitute decision-making order is quite attractive. But the problem, one of the big problems in Manitoba is that the legislation that recognizes supported decision-making only applies to people with intellectual disabilities, and I see that as a real limitation to that mechanism, and I mean there are others, but those are that's a big one. The third way that Canadian legislation recognizes supports is, to me, not that comforting, but appears in several different pieces of legislation. And what it does is it really it's a way to ensure that less alternative methods are looked at than having a guardianship ordered. So the legislation says something like a guardian. I mean, the language is different across Canada, but the point is basically that a guardianship can't be ordered unless there are less intrusive methods of decision making, and unless supports have been canvassed but there's no supports in place that can effectively allow the person to be able to make decisions without a substitute decision maker. So my paper goes through the details of all of the different legislative approaches, but that's basically a summary of how they work. One of the things, well, there are a couple things. One of the things from my review of the legislation is that Canada has not, although we've ratified, my paper goes into a lot of detail in relation to Canada's legal domestic obligations once we've ratified a convention, and I mostly set that out because we talk a lot about the significance of Canada's ratification of the convention, but when you do an analysis of the legal obligations within Canada to follow UN treaties, what we find is that Canada, although we're obligated in international law, is not bound nationally to follow the convention unless it's implemented. And so we do have a case that's been to the Supreme Court that dealt with the Convention on the Rights of the Child that was ratified at the time of the litigation, but the court said that notwithstanding that, the government hadn't implemented the convention, and so it didn't see itself to be bound by it, but that it was of interpretive value. So that's important because implementation basically means I mean, I'm not going to go through a whole sort of long dissertation about international law, but often we look to our legislation to see whether it is in line with the language and the intent of the treaty. If it's not, it can be hard to argue that it's implemented, and so it can be hard to get the courts to say that they're bound by the convention. And the reason I'm mentioning this is that I mean, the Canadian government, as far as I can understand, hasn't sort of made an official statement as to whether or not the convention has been implemented. But when I review the laws, and I'd be interested to know everyone else's opinions based on their review of how I've summarized the laws, but it doesn't seem as though any of Canada's provinces or territories have actually fully implemented Article 12. So I think there's a long way to go. I think if we piece together a lot of the features of the different legislations, we might get something that closely approximates Article 12. But we're just know, we're just not there yet. I don't want to go on too much because I see that I'm almost at 20 minutes and I have tons more to say. But what I would say is that I don't think we can look to Canada to say that any jurisdiction here would be sort of can be said to be compliant with the convention, but don't forget that parts of Article 12 and arguably Article 12.3 are civil, political, and cultural rights subject to progressive realization, which means that as long as Canada is working towards implementation, that's okay in the context of at least parts of Article 12. How many more minutes do I have?
About 6.
Okay. Okay, perfect. So then I think that the next thing I want to tell you about my paper is that in analyzing our legislation and seeing that there are so many gaps in terms of of our law's recognitions of supports, Michael and I have really tried to flesh out this concept of accommodation and government duty to provide supports. And partly that relates to the fact that what do you do about a province like Ontario or like New Brunswick where there really isn't any meaningful recognition of supports? And if we wanted to make an argument for supports, let's say in Ontario, what kind of legal tools do we have, and how can we tie that in with the convention? So what we do have in Canada is lots of human rights laws which recognize that private parties and the state owe a duty to accommodate people with disabilities. And so Michael and I spent quite a bit of time sort of talking about what that accommodation would look like and whose duty is it to provide what accommodation and what the legal limitations are what the legal limitations are for providing supports, because the duty to accommodate is not unlimited in Canadian law. So we spent quite a bit of time thinking this through, and also looking at the CRPD and knowing that at international law, a treaty needs to be, any specific component of the treaty needs to be interpreted in the context of a whole treaty. And so if we analyze, so I think that Article 12 really needs to be read in the context of Article 5, which I believe is the article that says that, I don't have it in front of me, but I believe that's the article that talks about the duty to provide accommodation. So I guess there are a couple of things which I don't have time to go into, but just suffice it to say that in Canada, there is a duty to accommodate. It's usually limited to the point of undue hardship. It may be that the duties on government don't necessarily have the same limits as the duty of private parties, and especially since the Canadian Charter of Rights and Freedoms applies to government and does not apply to private parties, and there are many different nuances to that duty. But what's interesting is that Article 12.3 talks about the state having to take appropriate steps. steps to provide for access to supports. And so the question in my mind is, to what extent is the duty to accommodation, which is found in Article 5, and the duty to provide supports, which is found in Article 12, how far does that go? Is the duty greater on the state pursuant to Article 12.3 than it is on private parties pursuant to our general laws of accommodation? And I really, I think it's really important to push the duty to accommodate. The reason being that it's a much broader duty than the legislative duties, certainly in Canada, are